Well, colleagues, welcome. Thank you very much indeed for coming to Speaker's House for what I hope will be a lively and thought-provoking series of exchanges. Human rights in the modern Commonwealth, from Magna Carta to the Commonwealth Charter. That is the broad theme of tonight. I'm very sorry to inform you that Sir Peter Marshall, from whom we were going to hear, is not well, and therefore he will not be able to be with us, and that's sad. We wish him a full and speedy recovery. But the very good news is that you are going shortly to hear from the noble Baroness, the Baroness Scotland of Asthal, and I think you'll richly enjoy that. In addition to welcoming my parliamentary colleagues from the UK, it's obviously a pleasure and a privilege to welcome all who are attending, and in particular to welcome those from Commonwealth parliaments. Some illustrious stars in the galaxy are here, and I had been proposing to reference, but I can't see him at this moment, a very illustrious representative academe in the form of Professor Vernon Bogdanor, but I can't see Vernon at this moment, which makes me think he's not in the room now, but I hope he will be. And if he comes along, then I feel cautiously optimistic that we will hear from him. Anyway, the theme is clear. Ladies and gentlemen, I'm but a parliamentarian and a speaker, but I'm not an historian. But I've always been told that in judging history, you should judge by the circumstances of the time. And I suppose a key question is whether a figure performing in the public square or in some other capacity is ahead of his or her time or behind it, or simply in line with it. Whether that person is, in very broad terms, a leader or a follower. And in initiating the celebrations of the Magna Carta last month, including last week, and of the 750th anniversary of the de Montfort Parliament, which is also a very important celebration as far as we here in Parliament are concerned, there have been a number of references to the nature of the Magna Carta, and indeed to the nature of the de Montfort Parliament. I think that many of you will be well familiar with some of the background to the emergence of the Magna Carta, an extraordinarily historically significant document, but not something that we would regard of itself as the embodiment of, or even really the blueprint for, a modern pluralist democracy. And of course, the Magna Carta came about as a result of historic struggles between different interests, including, of course, between very important and powerful landed interests on the one hand and the monarch on the other. Similarly, I think it's fair to say in relation to the de Montfort Parliament that it was a dramatically significant feature of British political development, and therefore has a special place in historical discussion about the development of Parliament. But that Parliament was not itself a beacon of human rights protestation, still less of human rights observance. I think it is unlikely that we would identify Simon de Montfort as being a thoroughly modern human rightist. In truth, of course, at that time, concepts of liberty and human rights tended to be invoked with no little zeal and enthusiasm by people who were seeking the protective curtain of liberty and human rights so far as their own interests were concerned. Whether it could be said they were greatly preoccupied with concepts of liberty and human rights more widely than their own interests is, I think, somewhat more doubtful. Now, that isn't to damn them. It's simply to place the matter in some sort of historical setting and context. But anyway, I've always thought amongst modern historians, if you want to read intelligently and benefit from doing so about the way in which our Parliament has developed, you could probably do a great deal worse than to read the celebrated works of Professor Linda Colley, who's charted the course of British parliamentary development extraordinarily powerfully and effectively. Here in Parliament, as you know, we are marking the Magna Carta and indeed the 750th anniversary of the de Montfort Parliament. Last week, for example, we had an unusual but really rather memorable event here in Speaker's House when the Worshipful Company of Bakers from the city very generously presented me, not for my personal consumption, but as Parliament's representative, with a very, very sizable and decorative cake, which was testament to the 750th anniversary. I immediately suggested that the youngest child present from the relevant school should be invited to consume the first slice. This turned out to be something of a diplomatic faux pas, though I was not aware of it, ladies and gentlemen, at the time, and it was a diplomatic faux pas on account of the fact that it contained alcohol, and the young pupil's religious convictions prevented her from consuming it. I was reduced to suggesting that if the icing didn't contain alcohol, she might contemplate consuming the icing. And I don't know whether in the end she did. But nevertheless, that was quite a happy occasion, and we were grateful, frankly, to the Worshipful Company and all those who attended for their recognition that the 750th anniversary does matter, and it is significant, and it should be noted. And subsequently, we got an indication, I think, from the BBC that there was really quite a substantial increase as a result of the events of the week in the numbers of people who were aware of the Magna Carta, who knew a bit more about it after than they did before, and similarly in relation to the de Montfort Parliament. We also had an event on Thursday, I think it was, of last week in the Chapter House of Westminster Abbey with evensong and tributes not only to the significance of the Magna Carta and the de Montfort Parliament, but to perhaps the most recent expression of young people's enthusiasm for democracy in the form of representatives of the UK Youth Parliament who were there for the occasion, which seemed to me to contain a certain piquancy. And you'll probably be aware that both Houses of Parliament, I say it is somewhat to my chagrin, and certainly to the House of Commons' shame, the House of Lords beat us to it in terms of drawing in the UK Youth Parliament and enabling them to debate their chosen topics on the red benches. But for the last 6 years, since 2009, we have, on a non-sitting Friday, had the UK Youth Parliament present, typically 300 plus members of it, in the chamber to debate subjects that they have voted to debate. And that, as I say, is the most modern and recent manifestation of an enthusiasm for democracy, for engagement, for people's right to express their views on their issues in what nevertheless is also their parliament. I might mention to you, ladies and gentlemen, in passing, that when the House of Commons voted to allow that to happen, and that was, if memory serves me, very early in 2009, or it might even have been at the back end of 2008, that it voted so to allow the UK Youth Parliament, it was a matter of some controversy. There were quite significant numbers of colleagues who were very much against and who took their stand on what they regarded as the sacred ground of the parliamentary chamber being exclusively for elected members. And their point was a quite simple and respectable one, that nobody had previously been allowed to speak in the chamber of the House of Commons unless they were elected members, and why should we break that very long-established convention? To which, of course, the counter-argument was, well, there is an exception, perhaps, that could be made, and we're sovereign, we can make this exception and not make others. And the reason why we would want to make it is that the UK Youth Parliament is overwhelmingly made up of people below the age of 18 who don't have the right to vote, but who are interested in politics and do feel some commitment and would like the chance to articulate their viewpoints. I happen to think, by the way, there's a second argument for allowing the UK Youth Parliament to debate in the Chamber of the House of Commons on a non-sitting Friday. They're not getting in the way of any other business. And that is that it gives a huge injection of pride and self-confidence to those young people. We're not only enabling them to hone their skills, though that we're certainly doing, we're also, in a sense, making them very properly feel that they are treated with respect. And my attitude to this has always been very simple. I voted for the right, and then I chaired the debate in 2009, and I've chaired the debate every year since. My reasoning is very simple. I think that if we want to be respected by young people, we have to show some respect for young people. Respect is a two-way street. It's not an automatic right for us to enjoy respect. It's what I would describe as an earned entitlement. The encouraging thing, and you may think, what's this got to do with Magna Carta and the de Montfort Parliament? It's got everything to do with the continuation of the democratic tradition and the attempt to nurture interest in the democratic process amongst the young. The encouraging thing is that now the numbers of people who object to the Youth Parliament coming here have dwindled virtually to nothing. At the time, and I won't say who because it was a private conversation, but at the time that we were about to hold the first set of debates, a senior member of the House of Commons, who is no longer a member of the House of Commons, he's now retired, came up to me in what I can describe only as a positively splenetic state, absolutely incandescent with rage at the prospect of the UK Youth Parliament coming here. And he said to me, Mr. Speaker, I understand, because originally the Chairman of Ways and Means, Sir Alan Hazelhurst, well known to you, was due to chair the debates, but I decided that I thought I should chair them. And I said, Alan, you can have the day off and I'll chair them. And he was only too happy to have an extra day in Saffron Walden, his constituency. And this now retired member said to me, Mr. Speaker, I understand that you are to chair the debates of the UK Youth Parliament. And I said, yes, that's quite right. He said, let me tell you, it'll be an absolute and unmitigated disaster. And I said, well, I'm very sorry to hear you say that. I'm afraid I don't agree with you at all, but, you know, what's your reason? I know what I'm talking about, Mr. Speaker. If I may say so. Sir, I've been here very considerably longer than you have, and I know what I'm talking about. I said, no, I know exactly when you came into the House. That is not a matter of dispute. My point is, what is your point? What's your argument? And he said, you mark my words, Mr. Speaker. If those young people come into this, I know the House has voted for it. The House has done a very foolish thing. He said, if those young people come into the chamber to speak, at the very least, he said, chewing gum will be left all over the chamber. And at the worst, you mark my words, he was virtually spitting in my face. He was absolutely red in the face. He said, at the worst, penknives will be used and damage will be inflicted on these benches which I love. And I said to him, well, you know, I respect your right to your view, and I respect you in the sense that I appreciate you being candid and saying this to my face rather than surreptitiously or behind my back. But I have to say, in another sense, I'm absolutely horrified that you should subject young people to this calumny. I mean, it's a complete and utter nonsense. Sorry, but it's utter nonsense. That is not going to happen. These young people, I make 3 predictions, will be proud to be here. They will speak well, and they will behave a damn sight better than we do. And although it is rarely popular in politics to say I was right, the truth of the matter is, and I say this not on my own account, but on behalf of the young people of this country, the members of the UK Youth Parliament, I was right on all 3 counts. And the great thing is now, as I say, everybody accepts it, lots of colleagues turn up to listen to what the UK YP members have to say, and it's all part of the attempt to build some sort of rapport with the electorate. And it seems to me that we should be innovative in thinking of all sorts of ways in which we can try to do so with very modern techniques. And, you know, I've just led a commission that's focused on the use of technology and how the deployment of digital technology by Parliament collectively and by individual parliamentarians might help us to legislate better, to represent better, to scrutinise better, to engage better, and to encourage members of civil society to engage better with each other. But there is also a role for the historic, and the historic does matter, and the Magna Carta does matter, and the de Montfort Parliament does matter, and the developments in our Parliament since do matter, including some that are of a very historic character. As somebody once said, we should be proud of the past, but we shouldn't live in the past. And tonight, if I may, I'd like to put it the other way around. We shouldn't live in the past, but we should be proud of the best of the past, and we should, in a sense, in an intelligent and open-minded way, be asking ourselves the question, what in those historic phenomena is still relevant today, and how building on and modelling ourselves on some of the enthusiasts of the past might we better our democracy. Sometimes I think that the concept of human rights gets a very bad and unfair press, particularly in some of, if I may say so, some of the more down-market parts of the press. The term human rights is used as a term of abuse. We should be really proud of the importance that we attach to human rights. And, there are different views about these matters, but I think, for example, that, what we've learnt from the European Convention on Human Rights is incredibly important. And by the way, it wasn't some extreme left-wing revolutionary who first expressed support and mustered wider support amongst others for the European Convention. It was actually Sir Winston Churchill, who, if I remember rightly, was a Conservative Prime Minister, and at various times in his life he was a Liberal and he was a Conservative, but he was never a left-wing revolutionary. I think the European Convention's a big deal, and we perhaps ought to discuss that in the context of our approach to human rights. And finally, before I pass on to Patricia Scotland, who's the most important speaker you could hear from this platform tonight, I don't want to be unduly provocative, but there's no harm in being a bit provocative. And if we are talking about human rights, what do we mean? And might we not usefully, as friends within the Commonwealth, talk about human rights for all of our people, including for the LGBT community? Now, I know that there are differences of opinion on this matter, and there are many, many Commonwealth countries in which it is illegal for LGBT people to live their lives in the way that they would choose. And it may well be that some of those differences will play out, and I don't think that's a bad thing. I think it's much better to debate these issues honestly and openly with respect for each other's point of view. I admit that I do have a very strong view myself in favour of LGBT equality, and I think to deny LGBT people their rights is demoralising, it's demeaning, it's dehumanising. It is frankly just plain wrong. And I would like to think that in the future that would change. But if there are opinions about the subject, I hope people will feel free to articulate their opinions in an open and explicit fashion so that we can have a genuine debate, because nothing seems to me to be gained by suppressing these issues and pretending that we all agree when we don't. Let's have the debate openly, and no better place to debate these issues, it seems to me, than in the British Parliament. And with that, you will be incredibly relieved to know, ladies and gentlemen, that my opening remarks are coming to an end. And what I want to do in welcoming Patricia Scotland is to encourage you to welcome her in the most fulsome fashion. I've been pleased to know Patricia for a good many years. She served with very, very great distinction in the last Labour government. She served as Attorney General. She's a lawyer of exceptional prowess, and she's also an incredibly engaging speaker. And that is why, amongst other reasons, you will be incredibly relieved that my speech is now over, and hers, ladies and gentlemen, enthusiastically welcomed by you, I hope, is about to begin. Patricia Scotland.
Well, firstly, can I thank you, Mr. Speaker, for that very warm welcome and for sending an incendiary device into the audience before I start. It is an enormous pleasure for me to be invited to come and speak to you today at the beginning, I think, of a very important Commonwealth conference. The first reason that I'm particularly grateful and humbled to be asked to do that is, as many of you will know, I am a classic child of the Commonwealth. I was born in a tiny island in the Caribbean, Dominica, of Dominican mother and Antiguan father. And any of you who know the Caribbean know that's a pretty dynamic mix. Because my mother, a devout Catholic, my father, a staunch Methodist. And those of you who know that two parts of the Christian community know it's a pretty explosive contribution to make to the world. But brought up here for the majority of my life in the UK. So a child of the Caribbean, brought up in what was at one stage seen as the mother country, and subsequently being permitted to participate in the mother of all parliaments. And therefore, if we look at the Commonwealth family, that is a very similar picture. Mixed heritage, mixed opportunity, mixed experience, but a very strong inner core. And the family in the Commonwealth is bound together by the rule of law, by common values, common experiences, and common aspirations. And as the speaker told you, I had the amazing privilege of being the first and so far only woman in our 800 years of history who was ever entrusted with the delicate and heavy burden of being Her Majesty's Attorney General. So as you know, we here in the United Kingdom and we here in the Commonwealth do everything incredibly fast. So 700 years, a mere bagatelle. And when I looked at the role of the Attorney General, that, like Magna Carta, finds its root back in the 13th century. And Magna Carta could have been something which happened and was forgotten, because although it's called Magna Carta, that's the Greater Charter, it was not the first charter, because there had been many before it. There was, going right back to Edward the Confessor, an opportunity for the people and the barons to negotiate what were the rights of the kings and what was the right of the people. But for many years, of course, the people did not include the ordinary person. The people were the nobles, the barons, and those of land and influence. And the first Attorney General, said to be the first Attorney General, was Lawrence de Brooke. He's often regarded as the King's Attorney, the first King's Attorney. It was around 1247, over 700 years ago, but later than Magna Carta herself. And the Attorney General, the first person to be called Attorney General, was John Herbert, who was appointed as the King's principal law officer in 1461. And his picture, if you go into the office of the Attorney General, can still be hanging on the wall. And the role of the Attorney General was always considered to be a very easy one. Let me tell you how one of my 17th century predecessors, Francis Bacon, described his role as Solicitor General. He said, "It's one of the painfulest places in the kingdom." And that the post of Solicitor and Attorney, he described it thus, as the extreme painful places wherein we serve. And all I can tell you, ladies and gentlemen, is nothing much has changed. So those of you who have been ministers of justice will doubtless remember that well. But the oath that I swore as Attorney General very much came from the Magna Carta. Because when I took office as attorney, I swore an oath that I will duly and truly minister the Queen's matters and sue the Queen's process after the course of law and after my cunning. I will duly in convenient time speed such matters as any person shall have to do in the law against the Queen as I may lawfully do, without, and I think these are the words that still echo in our justice system, without long tarrying, delay, tracking, or tarrying the party of his lawful process in that to me belongeth, and I will be attendant to the Queen's matters when I shall be called on hereto. And that oath came very much from the principles that were laid out in the Magna Carta. And often people say, why has this charter remained so relevant? Why does it resonate in all our countries? Why do we go back to it? And why is it still relevant now in 2015, after 800 years? And the reason really is that the Charter set out in its 63 clauses the real defining of the rights and responsibilities of the King, his barons, and a number of the other groups, the Church and the City of London. But it encapsulated the aspiration of what a real good government could aspire to do. And still some of the most important parts of the Charter remain the following. And this was originally, I think, part of the third part of Clause 3. It said, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. To no one will we sell, to no one deny or delay right or justice. Important in 2015, but important today. And Lord Bingham, who was one of our greatest former Lord Chief Justice, he was Master of the Rolls and a senior law lord and a Middle Templar, so I just want to make a full and frank disclosure. I too am a Middle Templar, and indeed the lawyers who took the Magna Carta to America were also Middle Templars, so beware of Middle Templars bearing gifts. Liberty comes after them. He said this, he suggested that these are the words I've just shared with all of you, which should be inscribed on the stationery of the Ministry of Justice and the Home Office. So every time they do something, they should be reminded of it. However, he went on to point out that Magna Carta did not embody the principles of jury trial, which was still in its infancy, or habeas corpus, or form that was yet then invented. So Magna Carta, the root. But I think it's also very important for us to remember how it started, because this came about not through the king's delight in wanting to do justice, but because, in essence, he was forced to it. The negotiations that the barons entered into with King John was because of his unpopular approach and the way in which he was trying to trespass those freedoms which the barons believed had been given to them since Edward the Confessor's time, and they wanted a solution. So his rebel barons at Runnymede provided a short term solution for a royal problem, which resulted in the Magna Carta, the Great Carta. And the English translation accomplished much more, and it laid the foundations for the rule of law and ultimately democracy all over the Western world. And the Magna Carta really did establish the principle that everybody, and that included the king, everybody was subject to the law. And so today, when we look at presidents and prime ministers and ministers and the heads of important institutions and captains of industry, Magna Carta says to them all of you, no matter how mean or great, all of you are subject to the rule of law. And it was also crucial that the Magna Carta talked about all free men had the right to justice and a fair trial. All free men. And of course, at that stage, free men did not necessarily mean free women. But the Magna Carta did do something for women's rights, because I was reminded today that before the Magna Carta, a widow could be sold, her goods and her person could be sold to another, and as a result of Magna Carta, it came to an end. So maybe Magna Carta should also be reminded and recognized as the first strike for the liberty and freedom of women. So Magna Carta had a thread, and therefore this 800-year-old document remains a universal touchstone of liberty, embodying freedom and human rights. Yet the Magna Carta has experienced quite a rough ride. It was annulled by the Pope 9 weeks after it was signed. It was redrafted 3 times until it was confirmed into English law in 1297, hopefully helped by the then Attorney General. And most parts of the Magna Carta have today been repealed, apart from the 3 clauses guaranteeing the liberty of the English Church, the privilege of the City of London and other towns, and that no free man shall be imprisoned without the lawful judgment of his equals. So the single most important factor of the Magna Carta is that it can be truly seen as the foundation stone of the English common law, the freedom of the individual, and the principle of habeas corpus. That is, of course, the right to free trial. And the Magna Carta has also succeeded in terms of its international impact. Most notably, as I've mentioned earlier, in the United States of America, as early pioneers to America took the principles of Magna Carta with them, which provided the framework for the Declaration of Independence and the Bill of Rights. So the US Constitution's 5th Amendment clearly reveals its origin from the Magna Carta. The federal government cannot deprive individuals of life, liberty, or property. As well as this, Magna Carta has been cited in over 175 cases by the justices in the United States Supreme Court, and it's therefore a foundation stone of American liberties. And so its relevance today echoes through our common law. And that leads us to the aftermath of the 2 world wars in 1945. Because we had suffered the indignity of seeing the world torn apart by anger, hatred of the other, at a time when the world literally believed it might have ended. The whole world had been aflame. And the horror of the number of deaths that took place in those 2 world wars brought together jurists from all across the globe to say we have to do something to make sure this never happens again. We must have a document which embodies the values of human life, of liberty, of freedom. There must be a minimum standard to which all humanity can attest. And from that desire for change came the European Convention on Human Rights. But it's very easy to misunderstand that convention, to think it's some new-fangled thing that arose out of the war simply. If you read the European Convention, what we see are the roots of Magna Carta. Because what is within the clauses of the European Convention is actually a distillation of what is the common law of England, Wales, and Northern Ireland. And the first time I read the European Charter on Human Rights, I actually started to laugh. Because as a young lawyer, it was suggested to me that the European Convention on Human Rights was very difficult and complex and structured and foreign. And what I read in the European Convention on Human Rights was what I later discovered had actually happened, that a bunch of common lawyers from all over the world, because what joins the Commonwealth, in most of our countries, we apply the common law. And what a bunch of common law lawyers had done was take out their pen and a piece of paper and written down on it the fundamental principles and bones which are embodied in the common law that we in the Commonwealth had enjoyed for many centuries before the European Convention of Human Rights was ever written. And so that is a cornerstone, not just of European law, but it's a fundamental part of the common law of England and Wales that was taken to the four corners of the world when British law was shared with it. So whether it was America, India, Africa, the Caribbean, the whole of our world was governed by the common law. And now, today, that common law still binds us. The jurisprudence that comes out of the courts, the Supreme Court of America, Canada, Australia, New Zealand, South Africa, name any of our 53 Commonwealth countries, all of us refer to the jurisprudence of all the other Supreme Courts to better understand. And that is linked in with the Magna Carta. And then where do we next see it? Because we turn next to the Harare Principles, which bind us as Commonwealth citizens and Commonwealth countries. And within the Harare Principles, you see the same echo. And most recently, of course, we now have the Charter, our own Commonwealth Charter. And within those principles, you see the Magna Carta reflected once again. And if I may, I'd just like to remind colleagues, and I'm sure you have, all of you, this by your bedside, and you can recite it with me. But it says some very important things in the Charter, which was signed in March 2013. Remember, it was 60 years of us working and being together, and the feeling was that we should embody in a charter the fundamental principles and the values that we all share, the values that have kept the Commonwealth family, the association of states, together. And everyone, I believe, generally wanted the charter to become an established, recognizable statement of what the Commonwealth stands for, accessible to all Commonwealth citizens, and a means to protect and promote the Commonwealth's core democratic values for years to come. And the commitments in the Charter should be upheld, adhered to, and kept under review by member governments, parliaments, and civil society organisations. So this is our living document. It's not a dead, sterile thing. It's a tool for all our governments to work together to deliver democracy, human rights, international peace and security, tolerance, respect, understanding, freedom of expression, separation of powers, the rule of law, good governance, sustainable development, protecting the environment, access to health, education, food and shelter, gender equality, importance of young people, recognition in the needs of small states, recognition of the needs of vulnerable states, and the role of civil society. But the most important three, I think, are democracy, human rights, and international peace and security. And I think the one on human rights is perhaps what we will talk a bit about tonight, because this is what we all signed up to. This is what it says. We the Commonwealth, are committed to the Universal Declaration of Human Rights and other relevant human rights covenants and international instruments. We are committed to equality and respect for the protection and promotion of civil, political, economic, social, and cultural rights, including the right to development for all, without discrimination on any grounds, as the foundations of peaceful, just, and stable societies. We note that these rights are universal, indivisible, interdependent, and interrelated, and cannot be implemented selectively. We are implacably opposed to all forms of discrimination, whether rooted in gender, race, colour, creed, political belief, or other grounds. Now, why were we so strong in the Commonwealth about those beliefs? I think the reason is because the history of the countries of the Commonwealth have taught us the painful consequences of unfair, unjust discrimination on any of those grounds. We saw the scars in war. We saw the scars in division in nations within states, black against white, rich against poor, one religion against another. We know the fruit of discrimination and its division. We also know that if the Commonwealth, if our world is to survive, we need the talents and skills and energy and commitment of every single one of our people. That each individual is valuable. Each individual has a skill which they can offer. And that if we allow one of our citizens to be discriminated against on an unfair basis, then we all suffer. It was not for nothing that it said all it takes for evil to prevail is for good men and women to remain silent. And so I think it's all of us remembering, for as much as they do this to the least of these, they do this to me. And if our common humanity is shared, then I think we in the Commonwealth can be the torchbearers for what justice really looks like. Because we do come from the four corners of the world. Every region is represented within our Commonwealth. Every religion is represented within our Commonwealth. Every colour, every creed, every orientation. And so in the Caribbean we say, this is me trying to be Antiguan, all of we is one. All of we is one. And I think we in the Commonwealth need to remember all of us are one. And if we want to have a Commonwealth which is thriving and able to achieve that which it can most powerfully achieve, then I think we have to hold on to the roots of Magna Carta, be proud of our common law tradition, which is embodied in the European Convention of Human Rights and in the Harare Principles, our Harare Principles, and in our Charter. And I think if we do that, then we could be a torchbearer for the rest of our communities across the world, because we in the Commonwealth could really demonstrate what family, what friendship, what unity means, doing it on a voluntary basis, not because we're constrained to do it, but because we choose. We choose justice. We choose human rights. We choose to treat every member of the Commonwealth as equal to the other. And then, as my children would say, we then rock.